Right out the gate, he lays down the charges: assault on a family member. And here's the kicker: because it involves her own daughter, the stakes instantly skyrocket. We are not talking about a minor squabble anymore. This is classified as a criminal assault case that could cost her up to a year behind bars and a $4,000 fine. And let's be real, when the victim is your own child, the court takes it extremely seriously. This is no small slap on the wrist. It's a family feud turned legal battlefield, with a judge who clearly is not in the mood for excuses.
Mr. Walker. Ms. Walker, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. If you were going to do probable cause, you have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge.
Okay.
On November 4th, 2024, an officer was dispatched to a family disturbance call at a residence in Harris County, Texas. The complainant, a 15-year-old, stated that the defendant, her mother, assaulted her after they got into a verbal argument. The complainant stated the defendant displayed verbally aggressive behavior towards her, grabbed a hold of the complainant's left wrist, and said, "If you come near me, I'll beat your ass," and began to engage in a physical altercation with the complainant. The complainant stated the defendant, using both open hands, placed the complainant in a headlock, and the complainant felt pain. Both law enforcement and CPS records indicate a history of physical altercations and verbal altercations between the complainant and the defendant, and the officer observed video footage showing the defendant acting as the primary aggressor towards the complainant and observed a minor injury cut on the complainant's left arm.
Now, this is where things shift from emotional accusations to hard evidence. The officer did not just rely on what was said, he actually reviewed video footage. And in a courtroom, video is like a trump card. It speaks louder than testimony. She can try to argue her side all day, but if the recording shows her as the aggressor, her defense starts to crumble. On top of that, there's a visible injury on the child's arm. One minor cut might not seem huge, but in front of a judge, even a small injury on a teenager is proof that the violence was not just verbal, it was physical.
So we have prior violence, any prior charges?
There's no prior
Any,
charges,
no
Your Honor.
prior injury to a child, felony charges?
No, Your Honor.
Child means 14 years or younger. Okay, ma'am, I'm gonna find that there's probable cause to go forward with your case.
No, Your Honor.
Don't. Now's not the time, ma'am. You have the right to remain silent. Exercise that right. I've got a bunch of DAs here. Anything you say, they're gonna use it against you. Guys, what do we do about contact? You know? Yeah, well, so Michael, I need your help. You know, this is a 15-year-old child. We have a history of violence allegedly between mom and...
Did you notice his shift in tone here? The second the words history of violence enter the courtroom, everything changes. Judges do not gamble with kids' safety. If there's even a suggestion of repeated aggression, she's going to lose sympathy fast. What she calls a one-time argument, the court may view as part of a dangerous pattern. And once a pattern of violence is established, the priority becomes crystal clear. Protect the child first, sort out her story later. That's why you can almost feel the judge's patience thinning as he weighs what's at stake here.
and daughter.
Yes, Judge.
Now we have an assault case against a 15-year-old. And according to what Alex says, there's a history of it. It's unacceptable.
Judge.
Do you have a lawyer, ma'am?
I'll be retaining a lawyer, but there's no history of violence between us.
You're calling for a walker?
Yes.
Which walker?
One Walker. In custody. Oh, thank you.
Okay.
So, well, my plan was, and I already spoke to my people about this, is we were gonna check the offense report to see where the child was taken. Were they taken to CPS custody, state custody? Was there some other guardian? Once we're aware of where the child is, we are going to be asking for a no contact order to be granted based off of the allegations and the history.
What about now? Is there something that we can do now as far as finding out where the child is?
Well,
You know?
we're going to call CPS today and see if they're in state custody. The offense report also might indicate where it is. If not, we can call the officer and they should know.
Yeah, I'd like to, because I think it's serious. I mean, if we have a history of violence, I don't want that to happen anymore.
There's no,
I know that you're telling me no, but I have other people that are telling me differently.
I've never.
Okay, well, ma'am, don't. Now's not the time. But my primary concern is the protection of every single person in Harris County, bar none. That's it. Especially if it's a child. And
I'm not a threat to my child, I promise you.
you are now charged with assault, ma'am, on that 15-year-old child.
I never assault.
Stop. Now's not the time. I'm just trying to tell you. If I find that there is a history of violence with the child, I'm going to order you not to have contact with this child.
I understand,
As it stands now,
but I promise there's no
I'm
history
entering
of
in
violence.
called a magistrate's order for emergency protection that identifies EJ as a protected individual. You
I
cannot,
have to take her to appointments and stuff like that.
please listen. Okay, I know that you're trying to think of stuff to say,
No,
but
I'm
I
being
want you to
honest.
listen, because this is very important stuff. And if you don't hear it correctly, you do something to violate this court order, they're going to file additional charges against you. I'm entering in an order for protection for that 15-year-old child. She's now a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. Typically, this also comes with a residential restriction that you're not to go within 200 feet of where she lives or where she works. You understand?
And here it is, the legal brick wall, an emergency protective order. Think of it as a force field around the child. No contact, no threats, no weapons, period. This is not just a suggestion. It's a binding order that can reshape her entire life. She cannot visit. She cannot call. She cannot even show up near her daughter's home or school. If she violates this, he won't hesitate to hit her with brand new charges, and those stack up quick. You can hear the judge making it crystal clear. His top concern is protecting the child, not sparing the mother's feelings. In this courtroom, her promises mean little. What matters is evidence, history, and the law.
Okay, I'm entering this order now. We will try to figure out about how we go from here, but my only concern is the protection of this child. To me, nothing else matters.
She's protected.
I know that you're telling me one thing, but the evidence will show what it shows, and that's going to point to whose side is correct. So for now, I'm just going to have them reach out to see where the child is and how we go forward. So for now, I'm going to have you sign a reset, and then we'll just have you take a seat in the jury box, please. Okay?